SkyKick UK Ltd, another against Sky Ltd and others.
My Lords, two preliminary observations, if I may. I noticed from the transcript yesterday that my Lord Kitchen asked more than once, what is the law we're applying, can we be clear on that? I have a suspicion there might be some loose ends, but to make sure there aren't, when I get to deal with the Brexit point a bit later on, I'll do a quick, shall I call it, an audit to make sure that your Lordships at least understand my position on that.
Your case spells it out in quite a lot of detail.
It does, but I made a mistake in my case, which I have to correct. In amongst this forest of legislation, I discovered after we'd done our written case that actually the UK government has repealed the 2017 trademark regulation, repealed it, which they have the power to do. So it's not actually retained EU law in this country anymore anyway, and there's other stuff to go with that. But I'll come to that in a while, if I may. The other thing is that I will need to address you at some degree of significant length in relation to the judgment of Lord Justice Arnold in Lidl and Tesco. Your Lordships will remember, or some of your Lordships will remember, that an application was made by Lidl to intervene in this case on the basis that there was, I'm paraphrasing, a bit of a fracture developing between the judgment in Lidl and Tesco in the Court of Appeal and the judgment from Sir Christopher Floyd in our case. That's certainly the impression that I have, and I will need to address you on that because it's of some importance to the profession as a whole going forward from where we are now. So with those two preliminary observations, I'm going to pick up on my DNA submissions, as I called them, just to give them a tag. The first point that I wish to develop is that two things were going on in parallel at the relevant period. The relevant period is the period which embraces the filing of the applications for registration which are in issue in this case. And you know already that the importance of that is that bad faith falls to be determined as at the date of filing of the application. The applications were filed at different points in time. They run through basically from 2002 to 2008. And during that period, there were two things going on which were cross-fertilising with each other, which affect the question of whether applicants were acting in bad faith. The first was that the case law was indicating clearly and progressively that there was no requirement for an intention to use in the trademark system. In the EU trademark system, no requirement for an intent to use. It didn't actually, at least to those who were following the case law, it didn't come as a surprise when the Court of Justice in the present case took the position it did, that merely having no intention to use was not of itself bad faith. It didn't come as a surprise. It was the culmination of a line of case law. And the second thing that was going on is what you may have seen referred to glancingly as the practice, pardon me, the practice which developed under Presidential Communication number 4/03. Applicants, and I'm going to show you this, if I may, in a short while, 16th of June 2003, applicants were told in direct terms that it was a proper specification for goods and services to do what my clients, and I should say, thousands upon thousands upon thousands of others have done with their filing practice in relation to goods and services. So on the first of those two strands, which, as I say, cross-fertilise with each other, could I ask you in the electronic bundle to go to page 182 in the bundle numbering? My Lords, these are the key passages from Trillium. A learned friend said that I'm relying on Trillium, which is a cancellation division decision, which is in the hierarchy of things a low order of decision, as if I'm relying on it as authority in your Lordship's court. I'm not. I'm identifying it for its date, for what it said, because it's, what should I say, the first staging post down the line, and other cases follow. The one I shall go to next is a case called SkyTech in the General Court. It's one in a line of cases that culminate in the judgment that we had in our own CJEU judgment about the significance or otherwise of a lack of intention to use. So if I could draw your attention, please, to page 182. Trillium. This was an application, as you can see, we've noted it there, for computer software and communications software. Those are the italicized
Sorry,
words.
can I just have the reference again? It's not...
Oh, sorry, page 182 in the electronic bundle numbering.
Yes, it's not.
It's in our written case.
Paragraph 71 of your case.
Yes, thank you very
it's
much.
71 and 72.
Yeah.
Thank you. It's in the bundle, but it's just as convenient for me and for your lordships to see it here. This was an application to register for computer software, communication software, and the allegation was made that it had been applied for in bad faith because it was overbroad, because all the applicant ever intended to do was to use it for telecommunications switching software, a species of software. And in those two paragraphs there, they're not the last word on the subject, but they're the ones that, as it were, scorched themselves into the perceptions and recollections of the trademark profession in the UK. That allegation of bad faith was rejected. It's unfounded, they say in paragraph 8, because under European trademark law there's no intention to use requirement, and thus the UK and CTM systems are different. Under UK law, an application for registration of a trademark is required to contain a statement to the effect that the mark is being used by the applicant or with his consent in relation to the relevant goods or services, or that he has a bona fide intention to so use the mark. And then they refer to sections 32.3 and 3.6, that's the bad faith provision of the UK domestic legislation. In comparison with the CTM system, the UK 1994 Act differs completely because the use in commerce is not a prerequisite for a CTM registration. In general and as a matter of principle, it's entirely left to the applicant to file a list of goods and services as long as he sees fit, i.e. a list exceeding his actual scope of business activity, and try later to expand his activities in order to be able to show genuine use of his CTM or face revocation under the relevant article at that time, and other sanctions respectively. It's exactly this liberal concept which underlies Articles 15 and 50 of the then CTMR, which is the 1993 CTMR, because otherwise a grace period of 5 years would make little sense, if any. There may be cases where an applicant files a list of goods and services where all or part of it doesn't have the slightest connection with his actual economic activity, and where it might even appear unimaginable that said applicant would ever be able to expand. If in such case the holder of the CTM immediately took action based on remote goods or services against third parties, it might be worth considering 51(1)(b), that's the bad faith provision in the CTMR 1993, but this can be left undecided because it's not the case in the present proceedings before us.
So maybe the area between those two is the area of dispute between you.
We would say it's been resolved by the CJEU judgment. What this did was to state the position in European Union law as generally understood in the EU IPO and all the other offices as to what the EU system allowed. They call it in their own way the first to file system. I have elaborated that as in my written submissions as it's titled by registration, not registration of title. But the sentiment is the same. You make a filing, you pay the fee, and you leave it to other people to knock you off in one way or another on one ground or another. Now, this Trillium decision was extremely well known. It was discussed...
Sorry, when you say leave other people to knock you off,
yes.
What exactly do you mean by that?
Okay, sorry, forgive me, didn't mean to sound familiar. So, the mark goes on the register after it passes the examination phase, and then if anyone wants to take it off on the grounds that it doesn't qualify for registration, so that's an absolute ground, the mark is too descriptive, it's contrary to public policy or any of those things, people can make an attack on it. That's an inter partes procedure. And the same is true of bad faith in the EU system. In the EU system, there is no bad faith objection capable of being raised until after the mark is registered. In other words, it's not a ground of opposition in the EU system to this day. In the EU system, you attack a mark for bad faith filing after it's been registered.
Mr. Hobbs, before you move on,
of course.
Can you just help me in relation to paragraph 8, please?
Of this, my lord, yes.
Does this mean that the same conduct could be held to be in bad faith for the purposes of the UK patent and not in bad faith for the EU, for the EU trademark, and not in bad faith for the EU trademark.
It did until we had our CJEU judgment, because our CJEU judgment answer to question 5 resolves that by saying you can't get, by section 32.3 in conjunction with section 3.6, you can't get what you couldn't get on a direct bad faith objection within the EU system.
So until that decision, you're saying there was some conflict going on between EU and UK domestic law?
Yes, it's been an extraordinarily difficult time to live through, and it went on. I sort of hazarded yesterday it was about 14 years. It went on. My Lord Kitchen will remember the prefaces and the forwards to successive editions of Curley, in which comments were made to the effect that this is a law but it can't stand, it can't be right, it's got to be looked at again. And we have at length in our written case, and I hope not too much length, but at least it's there, we call it the doctrinal disagreement. And so if you have, not far from where you are now, if you go to page 185 in the electronic bundle numbering, I'll just for a second ask you, I'll move from one lily pad to another on 185, 186.
Paragraph number, please.
Beg your Lordship's pardon?
Paragraph number.
Oh yes, I'm sorry. 84
Thank you.
In my written case.
Thank you.
So you see above 84 I've put the heading the doctrinal disagreement, and I've furnished it with particulars. So we had in 85 doubts being expressed by Mr. Justice Jacob in a case called Laboratoire de la Mer. Doubts again in the same vein in Red Bull, Mr. Justice Arnold. More recently there's been a paper published, it's still going on. More recently, there's been a paper published by the Right Honourable Professor Sir Robin Jacob and Dr. Lynn Chav, I hope I pronounced her name correctly, Registered Trademarks, a System in Crisis and What's to be Done About It. And then the judge himself, in our case, which is, he's never made any secret of the fact that he's opposed to broad specifications. Within weeks after delivering judgment at first instance in our case, having given permission to appeal to the Court of Appeal, he delivered a paper at the EU Trademark Law Conference in Alicante, which is at where the European Union Trademark Office is, and he published a paper headed Broad Specifications and Intent to Use, Is the EU Trademark System Credible? And you can see that block paragraph there. Now's as good a time as any to look at that block paragraph in 89 to see what the judge said. That was his view before ever the Court of Appeal pronounced in our case. And that, I think I can fairly say, that has remained his view, and you may see signs of that when I take you to Lidl and Tesco. So the judge says that he wasn't surprised by what they ruled on his clarity and precision questions 1 and 2. He wasn't surprised as to what the CJE ruled in answer to his question 4 about part cancellation. And then you'll see at the bottom of page 185, the jury is still out, however, with respect to the EU system's acceptance of broad terms such as computer software and specifications. The US trademark system doesn't permit applicants to seek registration in respect of computer software without further particularisation. Why should the EU system do so? Sooner or later, the CJEU will be called upon to grasp this nettle if the Trademarks and Designs Network does not do so. It is therefore disappointing that the EU IPO's reaction to the CJA's ruling in Sky was to say that as the court didn't question the clarity and precision of the term computer software, it also doesn't call into question EU IPO and member states' practice on terms lacking in clarity and precision reflected in the common communication, the common practice, and so on, and which I'm going to show you shortly. The judge has made no secret of the fact that he's opposed to broad specifications, and so this is why I took some pains yesterday to emphasise, Your Lordships, that it's actually not really a non-use case. It's what I called the granularity point. The way you attack a broad specification is to demand, to posit, to propose that there be a requirement for granularity and condemn the surplus over the granularity as bad faith filing for lack of intention to use. It's not a trick, but it's not the correct full frontal analysis of the situation. What the aim is of the people who, I don't want to sound dismissive, of those who are on one side of the argument or the other, what the aim of them is to establish a filing requirement for specificity. The whole aim of it is to make a filing requirement which isn't there in the law at the moment for specificity, and I classify that as granularity for reasons I'll try and tease out a little bit further as I carry on this morning.
But all these people, I mean, we're talking about highly respected judges like in this field, Sir Robin Jacob, including, I think you include the academics who've written on this, all seem to be saying, well, that's not much of a system. Broad specification doesn't sound, as a matter of policy, to be a particularly good approach.
Let me take that head on. My Lord is right. I don't want to sound impertinent. My Lord is right. That's the thrust of it. But with the greatest of respect, it's an agenda for change. What they want is a different system from the one we've got. They're proposing to go back to an intent-to-use system when we haven't had an intent-to-use system on the EU marks, 1.6 million of which have been migrated over to our register effectively on the 1st of January, I think it was 2021, but anyway, at the day we left the EU completely. They want a different system. There is no support for this that I can detect in any case law anywhere in the European Union. I can't find any support from it before we went to the Court of Justice, and I can't find any support for it now. The only people in the judicial system who've supported this would be the Advocate General. Advocate General Tanchev in our present case was supportive of these arguments, very strongly supportive of them, under the heading of public policy. Mr. Justice Arnold is firmly of the view that broad specifications are ipso facto a bad thing and would seek to introduce the granularity requirement on filing. And this has been, this is our case here in this court before your Lordships is the culmination of the debate that's been going on for 14 years or so. But the law in Europe has gone clearly in the direction it's gone, and I'm about to show you that the practice in the UK followed suit in relation to filing.
Well, I mean, it strikes me at the moment from what you're saying that the impact of Brexit may be crucial. I mean, we have an Act of Parliament in the 1994 Act. Section 32 requires a statement of the goods or services in relation to which it sought to register the mark, and a statement am I looking at three? Yes, a statement by the applicant that he has a bona fide intention that it should be so used.
Yes.
So Parliament's intention clearly is that there has to be an intention to use across the range of a description.
Parliament's intention is that there should be an application by the declarant.
Yeah, but you're not just going through the motions. The implication of what Parliament's saying is that it ought to be it's a condition of a valid application, and therefore it ought to be a condition of a valid registration.
Well, let me again take that point head on. Yes, that's what that legislation said, and there's case law at first instance, much of it from the appointed persons, and I'm a great admirer of the appointed persons system, including the case which has been cited from my Lord Kitchen, sitting at first instance, which was the Kindersnappy case, which cross-refers to a decision of mine in a case called Demon Ale, sitting at the same time. I venture to say, with the greatest respect, that neither of us could write those decisions now, certainly not in those terms. And the reason we can't is that the CJEU has ruled that Section 32(3) cannot be given the effect of a substantive objection.
Well, this is why Brexit may be important.
Well, again...
The whole point of Brexit, if you like, is that we do what Parliament tells us rather than what the CJEU tells us.
Okay. So the appellants ticked the box twice. Once when they sought permission to appeal from your lordships from the Supreme Court, and once when they filed their notice of appeal. This is not a case in which they're asking anyone to depart from EU law. We tick the same box on our side twice. The test, as your lordships know far better than I do, is to depart in the same circumstances as would apply to the Supreme Court or the House of Lords departing from one of its earlier decisions. I've seen enough to know that if anyone ticks that box, your lordships would normally convene a 7-judge panel. There would be proper notice, there'd be proper argument, and interested parties would have a chance to speak on such a matter. Nobody has asked your lordships to do that. But worse than that, speaking personally for a second, the most agonising experience for any barrister is to try and agree the statement of facts and issues with people you've been at war with for longer than the Second World War. But you will notice that in the statement of facts and issues, we have agreed that it's the question of whether the CJEU judgment was correctly applied in relation to the selected goods and services on the objection they raised.
Yes, you're making a fair point.
We're here where we are, if you don't mind me saying so. So now, just pressing on, if I may, yes, and I don't want to detract from the fact that there are perfectly respectable supporters of the view that the system is not fit for purpose. They're saying it never was, frankly. And this has, as you see from my next heading on page 186 in my written submissions, this has had a destabilising effect. It has created a situation in which trademark applicants have been in the position of a servant with two masters, because they go to the EU IPO and they obtain perfectly acceptable registrations according to the EUI procedures. They have the right to enforce them. They did until Brexit anyway. They have the right to enforce them in this country. We did here. And they come with all the attributes of a perfectly acceptable EU trademark filing. And we'll come in a second to show you what those attributes are. And then they are met with scepticism in varying degrees, but including up to this case, where the learned judge at first instance, Mr. Lord Justice Arnold, as he had by then become, takes the position that overbroad specifications are a bad thing, and that was the point of yesterday's exercise on paragraph 27 on that table. He didn't say, you're thoroughly bad people, go away and take your whole registrations with you. He trimmed us. And the trimming, as I was at pains to try and point out yesterday, was, in the great scheme of things, quite small.
May I ask this, Mr. Hobbs?
Yes.
Supposing the applicant filed with the degree of granularity that you've referred to,
Yes.
the various goods or services within the scope of that broad description, which might have been put forward as an alternative to the broad description. So you set out, let's suppose, 20 different kinds of goods or services, as the case may be.
Yes.
And you only have, perhaps on the basis that I put to Mr. Speck at one point yesterday, a putative intention subject to commercial realities and so forth, and the circumstances plainly change, but you have a putative intention to use it in relation to 2 or 3 of those 20 different groups of goods or services. Would that potentially be a ground of bad faith, and particularly if it were published on the register and it deterred competitors from using that mark in relation to the broader sets of goods and services which you've spelled out in your application.
So just to be clear, I'm envisaging an application for registration in which there are the broad, I'll call it for convenience, the class headings, and then beneath that you've got alphabetical listings of greater specificity and perhaps even greater granularity than that.
And perhaps even leave out the class description at the outset. So you set out what would in practice be the equivalent of the, the class heading with the degree of granularity that would be an alternative to taking that approach.
Okay.
And supposing that it is established that you only ever had any putative intention of any kind in relation to 2 or 3 of those goods or services. So there's a great deal set out in your application.
Yes.
And in fact, it's established that only a very small proportion was ever within your contemplation.
Right.
On the most optimistic basis of what might be achieved before the end of 5 years after the registration process.
Right. Okay, there are a number of points here at the surface and beneath the surface on that question, if you don't mind me saying.
Might I just give you one follow-up question, which is this. Why should one be better off, if it does make a difference, by filing the broad specification description at the outset?
Or why should you be worse off? Because if
or
it's
indeed,
acceptable,
why worse off?
why should it make any difference? I don't want to sound impertinent. The question is, why should it make any difference? This is two-way traffic. So, the practice statement I'm about to show you, which is the one from 2004, tells you, use the class headings, and if you want to, go on and itemize from the alphabetical list. It tells you, go down the line and use it. Now, there may be, perhaps at the back of those questions, the thought that, well, if instead of using the class headings, I produce a list from A to Z of, let it be 1,000 listings, potentially, or let it be less, I don't know. That perhaps there's a thought at the back of that I can sit there, I've got a forest of specifications, and I'm holding myself in a sense of self-satisfaction that if the time ever comes for strikeout, I lose that one, and that one, but I don't lose the others.
Indeed.
There's nothing wrong in that. There's nothing wrong in that. The system is designed, and I hope that by the time I finish my submissions this morning, your lordships will accept that the non-use framework, the grace period and everything that goes with it, it's actually the be-all and end-all of the system that we are discussing here, because it is the corrective mechanism, for better or worse, that is baked into this legislation. The people, I say people, and I don't want to sound disparaging, that those who voice the contrary view say it's not an adequate mechanism. It was consciously adopted by the EU legislator. It is a policy decision. I'm going to demonstrate that through the recitals of the legislation. They were perfectly aware of the mischief that's been cited against applications of the kind that we're considering here. They were perfectly well aware of it, but their preferred solution at the policy level was to use the revocation machinery as the safety net and the mechanism. And along with some other stuff I'll show you. That was
so the symmetry argument, the argument that there's a degree of symmetry between the application process and the revocation that was argued for,
yeah,
I think,
it's
on the other side, you say that's completely misconceived.
It is misconceived, and I do say that, and I'm going to furnish that statement with some support shortly.
Right. I'm sorry to go on, but just while we've got it open at page 182, I think we've still got that open.
Yes.
Paragraph 9.
1 second, my lord. You're back to Trillium. Yes, I've got it.
Paragraph 72 and the quote from paragraph 9.
Yes.
This idea that the holder of the CMT, based on remote goods or services, it might be worth considering Article 51(1)(b. And I think you told us that was a bad faith application.
Yes, it is.
So even in Trillium, it looks as if there's some indication that there might be a ground other than revocation for challenging this. Is that a correct interpretation?
That's what they said at this level. Remember, this is administrative level within the EU IPO system, but it's a respected administrative level. This is what they said in the year 2000. Right. The law's gone on. The law's gone on. I think I've read correctly in the controller's intervention that they want you to say that they should, we should or they should at the registry depart from, it's Pelican and SkyTech, I think, that they cite for this purpose. Pelican and SkyTech, but SkyTech in particular, which is my next citation to you, make it clear as to what the EU situation was, and then after I've shown you that, I'm going to be able to demonstrate, I hope to your satisfaction, that the UK followed suit on filing. Now, I'm not saying that there isn't an agenda for change, but the change is a change in policy. This is a fully occupied area by legislation. Legislation covers the whole field here. And in those circumstances, if anyone wants to propose change, it should be a legislative change. And in those circumstances, it's not with respect for your lordships by interpretation of provisions, especially when they've been interpreted by the CJEU bindingly for these parties in this case and for the law generally. I respectfully say it's not for your lordships by interpretation to achieve the policy change when the policy change, when the policy view is already baked into the existing legislation.
Although, I mean, the CJEU, in their decision in this case, have not said that you can do as you please, and they've said
no, they haven't.
It will be an abuse if you are using the registration to damage the interests of third parties,
yes,
or if you are
yes,
trying to acquire an exclusive right for a purpose other than the proper purpose of a trademark.
Yes, that's what they've said. But I think I'm entitled to say, I've got the Court of Appeal behind me anyway, and it is my case, I'm entitled to say that lack of intention to use is not of itself sufficient.
But that really begs the question: what are you doing if you're applying for broad specification of goods with general class headings or great degree of granularity? If you have no intention to use it in relation to that broad class, why are you applying? What is the purpose of it?
Well, because you're allowed to have a general description beneath the cover of which you're entitled to develop a business during the grace period and after. You're allowed to. That's the intention. And there are a number of points on this. I'm getting ahead, but I don't mind. I don't mind. Can we back up for a moment and ask ourselves what we mean by an intention to use? Yes. We had that from time immemorial, well, at least from 18 something or other, and it was part of the DNA of the Trademarks Act 1938 Act, and it was part of the DNA of the Trademarks Act 1905. I'm not sure of the position immediately before that. It said you can revoke in circumstances where the application for registration was made without a bona fide intention to use, and there has in fact been no use. That last bit was very important. I, in common, I'm sure, with my Lord Kitchen, in fact I know, practiced under the 1938 Act, and there was a lot of debate as to what exactly you meant by an intention to use. So, how imminent must it be? Can it be conditional? How much does optimism count or not count for you or against you? How concrete must your intention be? Now, there are many, many vagaries to do with the whole question of intention to use, and some of them came up in the course of the debate here yesterday with your lordships. So I can multiply examples. I'm an undergraduate on a Master of Business Administration course. I'm optimistic about my future. I register my name in a signature form because signature forms are prima facie distinctive, and I register it full of hope and optimism as to what I will do when I come out as a new graduate with my Master of Business Administration degree. But my hope might turn out to be unreasonable or unduly speculative. But if we have this test of intention to use and it comes into the bad faith analysis, look what will happen. Everybody who files an application for registration that then proceeds through to grant, every time they come to enforce it, will be tackled for bad faith filing insofar as the descriptive words go broader than what they can palpably be seen to have achieved under the period of the registration to date. Nobody will ever want to bring a trademark infringement action in this country again. It will be a death of 1,000 cuts, as I will come to in a minute, if I may. So, the intention to use is of itself problematic. Lord Justice Arnold, in that extract you just saw, said, why are we different from the American system? Well, the answer is that the EU legislator chose during the TRIPS negotiation to be different from the American system, and what's more, the American system has run into trouble even with its intent to use requirements. They've had to modify their law. So they have a Trademark Modernisation Act in 2020, which has made it easier than it ever was before to bring applications for cancellation on the grounds of non-use. Even with their intent to use procedures, they've had to bring in legislative reforms to deal with this problem, which is put up by those in favour of the intent to use solution. But I have set out in our written case the reasons which demonstrate that the EU legislator, in the negotiation process for TRIPS, made it clear that they were not adopting the American solution on this. I've set that out. So intent to use is problematic, but I'm going to come back, if I may, about what I just called the death of 1,000 cuts point, because I want to provide it with, provide your lordships with more to go on than just the rhetoric about a death of 1,000 cuts.
You're going to show SkyKick, are you one or two?
Yes, yes. So, could I ask if your lordships are satisfied that you've now seen paragraphs 8 and 9, and that we've discussed what it shows us at this moment? My point is, of course, I'm not relying in your lordships' court on this decision as being authoritative for my case. What you have here is a case in which an applicant for registration in the period immediately following the year 2000 files in accordance with standard procedures, doing exactly what the office required, and to say that the doing of that was bad faith in retrospect is, we would say, essentially unjust. Judging the behaviour of an applicant in the period 2000 to 2008 by a debate that's gone on over the years, with case law that's evolved over the years, culminating in the CJEU judgment now, and to switch that round and go backwards to the filing under the EU system, we say is completely unjust, or it would be. And I can show you it when I get to it, a case in the EU IPO, in the Court of Justice called Cactus, in which they said that people who use the EU system that I'm about to show your lordships after SkyTech, people who used it have, in the interest of legal certainty and legitimate expectations, the right to have the specification that was granted to them under that system, because the IP translator case had no retroactive effect. Now, that's as strong as I could get to show your lordships that it's not right, it's wrong in principle to judge the bona fides of an applicant back to the period we're concerned with from this end of the telescope. And this is a part of what I'm seeking to demonstrate here by these submissions. So I've established, I hope, what the position was. I'm not saying that this was the last word on the subject. I'm saying that Trillium was well known and well understood, and I could give you many examples of it being well known and understood, for the proposition that in the EU trademark system you don't have an intention to use and you have party autonomy over your own application for registration. I could give you ample material for that. Now, the case in which the next attempt, I argued it in SkyTech in the General Court, the case in which the next attempt was made to say that overbroad specifications involve a lack of intention to use for the surplus and therefore it's a bad faith filing, that was SkyTech. And so, if I could take you to page 2698. So just to put your lordships into the context, this was about a sign, and the sign was 16PF. And there was evidence, and it was the case, that PF stood for personality factors. And this was in the business, as you can see from the headings of the parties. If you look at the top of page 2698, SkyKick International, and the opposite party was the Institute for Personality and Ability Testing. So they were in the field of administering questionnaires of the type which they may still be popular, I don't know, when you're looking for new employees. You ask them lots of questions about different things. It's quite a long process, but you're looking to see how they score on personality factors. And there was a scheme or system which had been developed called the 16 personality factors. So the applicant for registration had, I think they'd obtained registration for 16PF, and that's what it stood for. And the attack was, so just to see if we can see what it was, that they, I'll show you in a second what they'd applied for, but if you look at page 2700, that's in the head note where they summarise what the court had found on bad faith, and I need to show you what the specification was in issue. Yes, if you go to 2701, in numbered paragraph 3, the goods and services were in classes 9, 16, 35, 41 and 42. Very lengthy. Class 9, computer software for use in behavioural testing. It's always there, right down the line. Class 16, printed matter, printed publications. These are standard specifications. And if I take you into the text of the judgment, if I ask you just for patience for one moment. Page 2712. You'll see that my argument is recorded in abbreviated form in paragraphs, specifically 82, but from 81 running forward. The applicant submits in essence that the Board of Appeal infringed 51B, that's the bad faith provision. First, according to the applicant, the bad faith is due to the fact that the number of goods and services in respect of which the intervener applied for and obtained registration is too large, and that the intervener had no intention of using the mark at issue for the entire list of goods and services in the application for registration. That's the point. It was being argued directly. This is sometimes referred to as the Anglo-Saxon or the UK argument on bad faith because of our tradition back to the 1938 Act of taking that point. And then there's a second limb. The applicant takes the view that the mark at issue was registered in bad faith because test materials marked 16PF had been provided to persons not trained by the intervener or the licensees and so on. But it's the one in paragraph 82, which is exactly the point, I believe, that is under discussion here at the moment. And then on the findings of the court under 51(1)b, they recited 86 what the legislation says. 87 says you must take into account all relevant factors, and no court has ever departed from that. This is always a case-specific, fact-sensitive finding. Bad faith is always individual to the case at hand. In the present case, it must be pointed out first that neither Regulation 4094, that's the Community Trademark Regulation, nor the case law provides a basis that would enable the court to find that there is bad faith in view of the size of the list of goods and services in the application for registration, with the result that that argument must be rejected. In any event, an examination of the goods and services in respect of which the intervener applied for and obtained registration shows that they are precisely the kind of goods and services which it provides in the context of its commercial activities. The intervener filed its application in respect to the goods and services for which it was using the mark 16PF or for which it intended to do so, and the specifications in the list are not too extensive in relation to its activities. Furthermore, on the basis of the material on file, it may be stated that the mark 16PF is already widely used for a number of goods and services designated in the registration document. Now, if you flick back, therefore, with those comments in mind again and look at 2701 and 2702, you will see that the breadth of the specification is not a matter for concern on a bad faith objection. This is one of a number of cases in which they say the width of the list or the breadth of the list is not a source of objection. That is consistent with what I've been saying to your lordships with respect, that you choose to describe your goods. You're not providing a shopping list. You're not providing a catalogue. You're identifying, I suppose, sectors of commercial activity in which you're engaged. You're not required. You were never required before SciTech, and you weren't, and you still aren't required, by the way, in the EU system, to have granularity in your application for registration. And the same is true in the UK. There is no requirement for granularity. Now, my Lord Kitchen was putting to me...
So in paragraph 90,
90, yes.
Page 2713.
Yes. Yes. Yes.
That's dealing with third parties' use of that mark or something similar to it.
That was a second string to my argument, yes. It's not the first, it's one of two strings, that's the second string. And that is a variant on what later came into the Court of Justice in the Lint Bunny case. This is saying you've got a registration, you're going to trample all over people out there who've been using it. This was a precursor to the Lint Bunny argument, my lord.
Thank you.
So, my lord, in the exchanges between myself and Lord Kitchen a short while ago, can I paraphrase it? And my lord will correct me if I'm wrong. There must be a point, or there must come a time, and that was where my Lord Burroughs was referring to paragraph 9 out of Trillium. There must come a point, or there must be a time, when the party autonomy and the right to describe goods and services becomes indefensible even within the framework of this system. There must come a time. Have I correctly paraphrased a point or part of a point that's being put to me? Yes, but not this case. But when? And trying to say when is... I've racked my brains over it. It's practically impossible. How near can you get to any type of explanation? Well, not with any great degree of confidence, but here's a suggestion. I'll use an example which is used when you teach students on this point. It's also an example which I heard Sir Robin Jacob raise in a meeting in Alicante once. I file an application to register a mark, and I file it under cover of a letter which says, P.S., by the way, I've got no intention of ever using this mark for anything, and if there's an application for revocation, I will not defend it. I won't have a position to defend. So that's the really stark example. And by the way, that, for testing the point, could be raised in relation to a single itemization of goods and services. You don't, in other words, leave aside how many itemizations there might be in the filing, just for this purpose, just to test or isolate the point. It's clothing. I've applied for clothing. Clothing is broad. Now, the application is devoid of purpose. It's defunct. If that's the state of affairs, it's defunct. And I'm using the word defunct because it echoes what you have in the ruling of the Court of Justice about the functions for which you can protect a trademark by registration. So it's devoid of purpose, it's defunct, and you're looking at what I'm going to call, just to give it a tag, a stillborn trademark. Now, if you had a case that was that clear-cut, of course you won't have an applicant doing that, but who knows, you might have a whistleblower or somebody in an organisation that says, P.S. you ought to know, I've seen the internal planning documents, they've got no intention, whatever. Now, it's no part of my case to argue that the registering authority couldn't intervene and say, look, it is devoid of purpose, it's an application with no purpose, no meaning, no content, it's defunct. Take it away. It would be the same as me, no, it wouldn't be the same, but it would be similar to me applying to study for a degree, choose any degree you like, and then saying, I've got no intention of turning up to any lectures during the next 3 years, and I've got no intention of sitting any of the exams en route or in the final.
So you would accept that in that, at least in that extreme example, that would be bad faith, even under the EU system?
I'm going to say yes, but I have to, you'll appreciate, I'm immediately saying it's not this case. Nothing is so clear-cut in the real world, but if that is what you could discern, I don't see why they shouldn't say it's a devoid of purpose, a defunct application. I don't see why they shouldn't say it.
And then immediately, of course, you open the door to the argument, well, if you can do that in relation to a single classification, the case you've given, clothing, never intending to use it for any purpose of clothing
anything at all.
You open the door, do you not, to saying, well, why can't that then be applied to a particular specification?
Because
which you've no intention of using across the board.
Well, no,
partly stillborn, if I might put it that way.
No, it's the partly bit that causes all the trouble. Because if I'm postulating, as I am, and that's as far as I'm going before your lordships with respect, if I'm postulating zero intent, I intend to do nothing with this mark. Ever.
In relation to the goods or services for which you're applying?
Take that, because all marks are assessed on that basis.
But then, again, you're immediately opening a door, because why should one be better off because you put it in one application than two? And you put in your one application a series of goods and services for which you have no intention, conceivable intention to use it, whereas if you put it in two applications, in the second one, it would be invalid for bad faith.
That's because in the example I'm postulating, there is never going to be any use within the grace period of any kind. It therefore never engages or enters the revocation regime. The revocation regime, as I've said, as I've sought to submit to your lordships, is the key to this case. It's the key to the structure of the legislation.
It would, with respect, enter into the non-use regime, wouldn't it? In both cases.
I thought I was postulating a situation in which nobody waits to the end of the 5-year period.
I beg your pardon. Yes.
In other words, before even the countdown begins on registration for the 5-year period, I thought I was dealing with a case in which it's proven to the requisite standard during the interim period before you ever get to the non-use period, such that the registering authority can say, well, just take it away. You're wasting our time. You're a time waster. But that's not this case. It's not the great multitude of cases. And as I keep coming back to it, and you'll forgive me for stressing the point, this case, as with... This case, like almost all of these cases, is about granularity of specification, which is not required at the front end. It's a back-end result after you've been through the revocation period. I was showing you SciTech. Is this me doing this?
Yes, it's been a problem with my computer.
Oh, I'm so sorry, my lord. Sorry.
No,
Can you switch the sound off?
yes, it is off. Yes, but I apologise, Mr. Roberts.
I've shown you SciTech. I've shown you that the argument was put, and that is the argument. Overbroad specification has encapsulated within it no intention to use. across the full width. And you've seen the answer the court gave, and that answer, as we've noted in our written submissions, has been repeated in a number of cases. Pelican, it was said in this case, and it was also said in the general court in the Neuschwanstein case, the Markham Verban souvenir case. Right, so I wanted to show you, if I may, what the procedure was that my clients were working under at the time when these applications were filed in the EU system, and to show you the UK counterpart. So may I ask you, please, to turn to page 3074. This is the communication number 403 of the President of the Office of June 2003 concerning the use of class headings. As the judge noted in his judgment, this clarifies what was already the existing practice in that office, and this continued to be the practice until 2012, the day after the IP Translator case. The court delivered judgment in IP Translator. So, under item heading 1, organisations representing community trademark applicants and proprietors have requested clarification of the practice of the office regarding the use of class headings and the consequences of such use when community trademark applications or registrations are restricted or partially surrendered or are involved in opposition or cancellation proceedings. This communication is intended to explain and clarify. A community trademark application must contain a list of goods and services in respect of which registration is requested. This is a filing date requirement. Pursuant to Article 28 and Rule 2, goods and services in respect to which community trademarks are applied for shall be classified in conformity with the common classification referred to in Article 1 of the Nice Agreement. The common classification administered by the International Bureau, WIPO, consists of a list of classes together as the case may be with explanatory notes, currently comprising 34 classes for goods and 11 classes for services. Each class composed of one or several general indications, commonly referred to as the class heading of a certain class, and of the alphabetical list of goods and services that currently contains 12,000 entries, together with the proper classification. Pursuant to Rule 2, the list of goods and services must be worded in such a way as to indicate clearly the nature of the goods and services and to allow each item to be classified. 3. The Office strongly recommends that applicants properly classify their lists of goods and services in the application and group them together in the order of the Nice classification. If this is not done, the Office will invite the applicant to remedy that deficiency pursuant to the rules. This will necessarily lead to a delay in the treatment of the application. Then this, and you'll notice several times from now on they use the word proper. It constitutes a proper specification of goods and services in a CTM application if the general indications or the whole class headings provided for in the Nice classification are used. The use of those indications allows proper classification and grouping. The Office does not object to the use of any of the general indications and class headings as being too vague or indefinite, contrary to the practice which is applied by some national offices in the European Union and in third countries in respect of some of the class headings and general indications. It is further permitted to use a general indication mentioned in a class heading of a certain class and in addition more specific goods or services covered by the same general indication, falling within the same class. For example, it's possible to indicate in Class 16 printed matter and also books, newspapers and magazines. This, in the Court of Appeal, Sir Christopher Floyd said this is essentially no different from subordinate claims, a main claim with subordinate claims. That was in argument, he said that. The 34 classes for goods and the 11 classes for services comprise the totality of all goods and services. As a consequence of this, the use of all the general indications listed in the class heading of a particular class constitutes a claim to all the goods or services falling within this particular class. Similarly, the use of a particular general indication found in the class heading will embrace all of the individual goods or services falling under that general indication and properly classified in the same class. For example, the use of the general indication pharmaceutical and veterinary preparations in Class 5 will embrace all pharmaceutical preparations regardless of their composition or indication. Furthermore, where it may not be obvious under which of several general indications particular goods or services fall, there is nevertheless a classification-based reasoning for the proper classification. For example, computer software is classified in Class 9 because of the presence of the general indication data, processing equipment and computers in that class, because computer software is seen as directly relating to the corresponding apparatus or equipment. Then you see this. Therefore, when a specification contains data processing equipment and computers as a general indication, this will be considered as embracing also computer software. On the other hand, where a specification lists general indications in Class 9 but not data processing equipment and computers, computer software will not be considered as falling within the specification. The effects of the rule that the use of the class heading constitutes a claim to all the goods or services falling within the relevant class, and that the use of a general indication constitutes a claim to all the particular goods, become apparent where the Office has to deal with a request to restrict the list of goods and services pursuant to Article 44 or with a partial surrender pursuant to Article 49. They become further apparent when the identity of similarity of goods or services is to be judged pursuant to Article 8. As regards restrictions and partial surrenders, it constitutes a proper restriction and not an inadmissible extension of the list of goods and services when the list of goods and services of a community trademark application or registration that originally contained the complete class heading of a particular class is composed of one or more specific goods or services properly classified in the same class and the class headings. Similarly, it constitutes a proper restriction and not an inadmissible extension of the list of goods and services if a specification is limited by deleting a general indication and instead selecting one or more specific items falling under the general indication. In the example cited above, it's proper to limit a specification to computer software when the original specification contained data processing equipment and computers, but it wouldn't be proper to do so when the general indication was not found in the original specification. Now that's enough for your Lordships to see what the system was that was in place at the EU level through the whole of the period with which the EU trademark registrations in this case were concerned. And I must stress that it is a complete misunderstanding if anyone was to say or suggest that my clients were, as it were, the only people that were doing this. The whole of the system was operating on the basis of this notice from that point in time. At least it was before, but undoubtedly from that point in time onwards. Now, the IP translator case was decided, judgment was delivered on the 20th of June 2012, and with, what shall I say, the sound of squealing tyres and the smell of burning rubber, you got a practice statement which you'll see on page 3069. 3069, communication number 2 of 2012, of June 2012. I'll pick it up in the bottom paragraph on 3069. In its judgment in IP Translator, the Court of Justice has ruled on the standards of clarity and precision to be applied to the classification of goods and services and on the principles applicable to the use of the general indications appearing in the class headings in the following terms. And then they quote from the judgment, which had been delivered the preceding day. So, at the top of page 3070, the directive must be interpreted as meaning that it requires the goods and services to be identified by the applicant with sufficient clarity and precision to enable the competent authorities and economic operators on that basis alone to determine the extent of the protection conferred by the trademark. The second ruling is particularly important. must be interpreted as meaning that it does not preclude the use of the general indications of the class heading of the classification referred to in Article 1 of the Nice Agreement to identify the goods and services for which the protection of the trademark is sought, provided that such identification is sufficiently clear and precise. An applicant for a national trademark who uses all the general indications of a particular class heading must specify whether its application for registration is intended to cover all the goods or services in the alphabetical list of that class or only some of them. If the application concerns only some of them, the applicant is required to specify which of them. So the instruction there, coming after the IP translator case, is if you've covered, by use of the general headings, you've covered everything under the previous practice statement, but you don't intend to, send us a list from the alphabetical list of everything you want to cover that's in there. It's not saying don't do it, it's saying send us the list. And there were filings, ample numbers of filings during the period following this, in which people took that step, and they were sending lists of, I think in some cases hundreds of pages of length, but that may be an exaggeration, but they were vast lists being filed in accordance with this ruling. That's the atomization then. So, going forward at item 3, in view of the above statements by the court, applicants are not precluded from using the general indications to identify goods and services, subject to being clear and precise. The office will continue to accept the use of general indications of the class headings, but on a case-by-case basis. This will be specified in the guidelines of the office, which will be periodically adapted to that effect. Until the guidelines are adapted, any such practice indication will be reflected in the office's manual of trademark practice. In order to determine which indications meet the requisite standard of clarity, there's a convergence program working on it. And they are basically saying, if I go to Roman 5 on 3071, as regards trademarks registered before the entry into force of the present communication, so that's all of my clients in this case, which use all the general indications listed in the class heading of a particular class, the office considers that the intention of the applicant in view of the contents of the previous communication was to cover all the goods included in the alphabetical list in the edition in force at the time when the filing is made. That is without prejudice to the application of Article 50. What's Article 50? I forget. And what they're saying is, in this practice notice, we're changing our practice going forward. The message is we're changing our practice going forward. And that led to 2 cases in the Court of Justice saying, just a minute, if the IP translator case has declared the law, it should be treated as always being the law, so why is it that you at the office are only going forward with it and not looking backwards with it as well? And that led to litigation, which I will come to in the form of the Cactus case, but before I do that, may I show you what the corresponding UK practice was? So could I ask you to turn to 3287. This is from, you'll see it was this one was last updated on the 13th of June 2000. This is from the year 2000. This is Practice Amendment Circular PAC 1000. And you'll notice examination of wide specifications and objections under Section 3.6 of the Act. That's the bad faith provision. Classification, examination of wide specs. This Practice Amendment Circular provides details concerning changes in practice in dealing with applications filed with broad specifications. The present practice is to raise bad faith objections under Section 3.6 to any specification which includes a claim to all goods or all services in any class, and to wide claims made to statements of goods and services in the classes that they set out by number. Following the updating and issue of the Guide to Cross-Searching of Trademarks, consideration has been given to the question of whether there is a real need to continue to raise objections under Section 3.6 of the Act in relation to overly broad statements of the goods and services in all the classes listed above. Moreover, the current UK practice should be viewed in the context of overlapping rights provided by registration at OHIM as the EU IPO and designation via the WIPO, that's the World Intellectual Property Organization, under the Madrid Protocol. With the exception of Class 42 heading, which includes the vague description services that cannot be placed in any other class, neither of those organisations challenge overly broad specifications. This is before the practice direction from the EU IPO 2003, yes. And they're about to say, they're coming into line with what's going on already that they know about in the EU IPO. So the revised practice. Section 3.6 objections will continue to be raised in all classes where a claim is made to all goods or all services. These descriptions are too vague and don't constitute a proper list of goods or services. Applications filed in respect of specifications that are expressed as statements of goods or services, e.g. the headings to that's the Nice Agreement classes, will not in most cases be subject to a broad specification objection check. The exceptions are classes 7, 9 and 42, and in those classes the following practice will apply. So they set out 7, 9 and 42. If you look at 9, because 9 is one of those which is an issue with us here, 9, claims to electrical and or electronic apparatus, devices, equipment and instruments will be objected to whether listed separately or in combination. And then it says, claims to the remainder of the Class 9 heading will be allowed, i.e., and that's the rest of the class heading, and you'll see that they allow data processing equipment and computer. I think there's a word missing, but data equipment and computer, fire extinguishing apparatus. They will allow them. No bad faith objection. That was the position in the year 2000. It moved on in 2002, so if I take you to 3292, what you're looking at here is the update to the one I was just looking at. Background tells you that item paragraph 3, section 3.6 objections are currently raised in class 7, in class 9 for claims to electrical and electronic apparatus, so that's recapitulating on what was said in the last notice. And then updated practice. Section 3.6 objections will...
Beg your pardon, Mr. Hobbs. Could you give me that page again, please?
The one I'm on is 3292, my lord.
Thank you. Yep.
So on that page, they're stating where they got to after the last practice notice, and now they're stating the updated practice beginning at 6. Section 3.6 objections will continue to be raised in all classes where the claim is to all goods or services. These descriptions are too vague and don't constitute a proper list. Applications filed in respect of specifications that are drafted in the form of the headings of the International Classification as listed in the 8th edition of the International Classification will not in the main be subject to broad specification check. The exceptions are class 7 and 45. So they've taken class 9 out of their preamble, but they still refer to class 9 on the next page, 3293. Applications filed in Class 9 which continue to make reference to, and that's the form of broad specification, will be objected to whether listed separately or in combination. The effect of that is that they will not object to the class headings in Class 9 on Section 3.6 bad faith filing grounds, and this is the 19th of June 2002. They're in line, and they know that they're intending to be in line with the EU IPO practice. And then that was carried forward of relevance for the period we're concerned with. If you look at 3290, this is the 12th of April 2006. Of course, by now we've had, not only have we had Trillium, we've also had the President's Notice of 2003, and this is the UK IPO in essence and substance following suit. And they're making it clear that there will not be bad faith filing objections across the generality of the headings to the classification of the 8th edition of that classification of the Nice Agreement. And they repeat the only caveat on Class 9 is the one that they had in the previous notice. Now we looked, in order to be able to show your Lordships as best we could what the current practice is. And if I take you then to 32, would you bear with me for 1 second, please? Yes. Right. 3275 opens the document. (3277) identifies the purposes of this addendum. When did we down? This was on our printed download, last updated the 3rd of May 2023. So it's as close as we could get to a current statement. Could I direct you to 3278? This is today. Internet services, online services and associated goods. Bottom of page 3278, classification, acceptable identifications of goods and services and explanatory notes. Class 9, computer software downloaded from the internet, that's fine. Computer software supplied from the internet, that's fine. Electric publications downloadable, similar. Computer software and telecommunications apparatus, same. Computer software to enable searching of data, the same. That's what they say today on Class 39. On 3280, you'll find Class 38, telecommunications. These are acceptable. Electronic telecommunication of information, including web pages, computer programs, and any other data. Electronic mail services, providing access to computer databases, providing user access to the internet, telecommunications connections to the internet, and so on. Can I take...
I mean, ultimately, this only takes you so far. I mean, this is telling you about the formalities of filing. The CGEU is telling us that filing in broader terms than you intend to use may nevertheless be an abuse in the circumstances described in the judgment.
I beg to differ with respect that it's telling you that you're filing in terms which are broader than you intend to use. My position is that they are saying that if you file without an intention to use, but you have the positive dimensions of what they specified in their ruling, then in those circumstances there can be a bad faith objection. The question is whether you're filing without an intention to use if you use the general words to describe the area in which you wish to engage.
But don't they also deal with the situation where the description is broader than the actual intention?
I'm not recollecting that.
I thought there was something about that.
Certainly this was...
Wasn't it the final question that was asked?
The final question...
Oh, it's the last sentence of the depositif.
Give me 1 second.
When the absence of intention to use concerns only certain goods or services referred to in the application constitutes bad faith only insofar as it relates to those goods or services.
Yes. But that brings you back to the question I've focused quite a bit of attention on, which is the wording you use to describe something doesn't import an absence of intention to use when you have what the judge found in our case on that table on paragraph 27, a real and substantial interest in the area of economic activity covered by the wording you've used.
Well, if I may say so, it seems a very formal point to take. You're saying it's okay if you use a generic term and you only, which covers a vast range of activities of goods and services, yes, and you only intend to use one of those.
Yes,
that's fine.
Yes.
But if you listed individually the 1,000 individual types of service that might be covered by the generic description, and you only intended to use one of those, that would be an abuse.
I'm not conceding that last point. I'm just saying that there are two ways of writing how you want to identify the area of trade in which you wish to engage. There are two ways of doing it. One is with a description in the general terms which have been specified, standardized and put forward, or you put forward a long list of goods or services, and you can do it that way if you like. But it doesn't actually alter the fact that the use of the general expression is a satisfactory way of identifying the area in which you wish to engage.
Mr. Holmes, maybe you said, well, there's a preceding question, which is, what actually is your intention? And if your intention is only to use it on a putative, optimistic basis in relation to particular goods or services, then whichever way you describe the broader class of goods or services which you ultimately seek protection, there must be a way of cutting it down before you get to the end of the 5-year period after registration.
I'm not accepting that. I'm not accepting that. And the case law in England, so can I, where was I? May I just finish on this and then take you to another section of to make this point? Because I am adopting a position which has been adopted by Mr. Justice Newberg and Mr. Justice Newgee, Mr. Justice Sales and others, and Sir Christopher Floyd in the Court of Appeal. My position is the same as theirs, and I need to just put you into context on that. While I'm on this document, so I was showing you pages 3280, 3281, and then I was showing you on page 3284, software as a service. That's another acceptable term. Now, the only purpose of having these terms and having them being told that they're acceptable is that you as an applicant shall use them as standardised terms. All registries want standardised, or prefer standardised terms. The alternative is a bespoke specification of goods or services, and I shall comment on the question of what that would or wouldn't involve in a few sentences from now. So I was just going to show you, in response to my Lord Reed's point, could I ask you then to look at electronic pages 184 and 185?
Just before we go there,
Yes.
the precise status of those practice directions, I mean, clearly they're designed to assist people who are filing, but they don't, as I understand it, preclude somebody from then challenging that filing if, for example, it could be shown that there was some strategy being adopted in relation to multiple filings that might be said to constitute an abuse of the system.
I'm going to agree with that, but I'm going to qualify it because I need to. I'm going to qualify it with the proposition that if you're going to accuse someone who's doing what the system tells you to do, doing it in bad faith when they do it, you're going to have to show additional criteria or factors beyond the doing of what the system legitimised. Because otherwise you're going to just look from this end of the telescope and punish people backwards in time for doing what was more or less required of them at this time in the EU IPO. That cannot be just and fair. And bear in mind that an objection on bad faith filing has no time limit. That's part of the problem with it. You can go back 20 years if you want to, and then imagine trying to defend it if somebody does. Again, may I come to that in a second? I was just going...
But you're more or less then saying, well, those practice directions become definitive statements of the law by which we're all bound.
No, I'm saying that anybody who abides by those practice statements is, and with the benefit of a presumption of acting in good faith, can't be accused just for doing so on the basis of having acted in bad faith. So that's wrong. That's just wrong.
And can you help me, Mr. Hobbs, on this point? If you have the alternative of either using a broad instruction such as I don't know, mobile applications.
Yes.
Alternatively, you could have a more detailed breakdown, and there's then a failure. Well, you then get somebody complaining that there's been no use within the 5 years in respect of
Yes.
some matters that are covered.
Yes.
Does it make a difference then whether you opted for a broad categorisation or a more detailed description?
Right, so that is a well-trodden area in the case law of the court and the case law of our national courts. I think I'm still right in saying that the most recent case in the Court of Appeal in England on that is Merck versus Merck, which my Lord Kitchen will remember. So when you're beyond registration and somebody can attack you for having a continuous period, remember it's got to be a continuous period of 5 years non-use, they will look at your actuality of your use and they will cut down your specification, and it will be done in a way which provides fair protection. It doesn't, as it were, to take a metaphor that was, I think, attributable to Mr. Blanco White, it doesn't cut you down to saying you can only have 5-holed razor blades from Venezuela, I think was one of his metaphors at one point. It doesn't require you to be that detailed. You can have a generality in your description, but the aim is to identify goods of the kind, not the particular goods, but goods of the kind for which the mark has been used, and to describe them in words of the kind that the relevant average consumer of the goods concerned would attribute to goods of that kind. I'm stressing the word kind, and I'm paraphrasing on some law.
Thank you, that's very helpful.
Do we need to have a look at Merck, at least briefly at some point?
I'm really pushed for time.
Yes.
I've got quite a bit to get through, and I'm already beginning to feel a little bit tight. Where was I? I was asking you to look at 184, 185.
You'll obviously allow yourself enough time at the end of the day for us to look. I mean, at the end of the day, we had Lord Justice Arnold finding that on the facts, the test set by the CGEU was met in this case.
I know.
And the Court of Appeal taking a different view on that issue. So, I mean, at the end of the day, is another thing.
Yes.
Another case.
Well, I mean, stepping back from it, from looking at it from where I'm standing, the injunction has been upheld twice. The infringement has been found twice. The width of specification that Lord Justice Arnold, I must call him, allowed us was narrower but still broad enough to catch my opponents for infringement. And therefore, it's my opponents who are actually asking your lordships to set aside 2 judgments of the Court of Appeal to get back to ground zero and to give them a specification that will let them off infringement. I mean, I'm not as familiar with your lordship's course as your lordships are, but that seems to me to be a rather big ask.
Lord Justice Arnold found as a fact that these marks, that you were using these marks for an improper purpose. And the Court of Appeal considered that he had misdirected himself in arriving at that finding.
On the selected goods and services?
Well, you see, that's the sort of point that at the end of the day we're going to have to focus on.
Well, the statement of facts and issues is explicit as to what we agreed, and a point to reiterate what I said yesterday, there is 0 adjudication capable of being the subject of appeal to the Court of Appeal or to your lordship's house on anything at all to do with validity of infringement or infringement of anything other than the selected goods or services. That defined the judgment at first instance in both of those dimensions and the Court of Appeal, and as far as the parties have agreed, that defines the issue to your lordship's house. Court.
I mean, he says that these registrations of these trademarks were part of a deliberate strategy of effectively setting up legal weapons that could then be used, and indeed were used many hundreds of times, everywhere from Albania to Yemen, something of the kind. And he gives examples which were not to do with the selected goods and services.
He does.
And that really is what the Court of Appeal had fastened on. The fact that they were to do with whips and footwear and
yes.
so on. But he nevertheless makes a finding in general terms that the trademarks had been registered in the terms in which they were for an improper purpose.
But he didn't.
I'm just suggesting you might want
I understand.
to cover the point at some stage.
I understand. Well, I believe I am by saying to your lordships that the judge made that statement about legal weapons, and he's gone back to it, and it's all over my learned colleagues' papers. But when the time came to bite the bullet, he didn't say, "You're all dead, go away, take the specifications away." He didn't say, "You're all bad, you're finished, you're tainted." He didn't approach it as if it was an application for a firearms certificate requiring a certificate of fitness to hold one and a character reference. He didn't do that. He looked at what even the judge, who was not favourable to my position, formulated that table on paragraph 27, which sheds light on what he could only have ever meant when he said bare legal weapons or legal weapons, because to the extent that he allowed us to have what he let us have, we were plainly on the right side of the test he'd previously mentioned. Otherwise, he wouldn't have let us have it. It was solvitur ambulando, look and see what happened. And the one thing he didn't do, in referring to the vigorous enforcement of our rights, he didn't point to, at least if he did, I can't remember it, he didn't point to a single instance of it being an unjustified or improper enforcement. There's no question of calling into doubt any judgment or order or consent agreement that may have been obtained. There's no question of anyone being hit or hurt improperly, and all trademarks are legal weapons.
Well, you're saying that even if we were to be against you on your main thrust of your argument and were to be with Lord Justice Arnold, nevertheless, if we follow what he does, you still win.
Yes, that's a judgment. I mean, the parameters for the case, in terms of all judicial determinations, all judicial orders, the parameters for the case are the 8 selected goods and services. When it came to argue what the form of the injunction should be, the other side argued against me that we shouldn't have a general injunction because we were guilty of partial bad faith, and that in those circumstances we should be turned away from relief. And the judge said, and it's in our document, the judge said specifically, no, the Court of Justice has ruled. You can only take it away insofar as it's tainted by bad faith. Insofar as it's not, it stands. And that, in principle, in my respectful submission, is correct.
Can I just ask a follow-up point from my Lord Kitchen?
Yes.
So it was to do with what happens in the revocation action. Let's assume that we've had something that has been widely phrased. Let's just use computer software.
Yes.
After the 5 years, if one was to challenge that for non-use, I assume you would accept that after those 5 years you couldn't be left with a continuing trademark for computer software if that was far too broad to cover what Sky has actually been using the computer software for. In other words, you would restrict, would you not, the types of computer software?
You would restrict. What the judge did in our case here is indicative of the way such a revocation application would be approached.
Right.
And you'd be left, as I understand your submission, with a fair description of the actual goods or services in relation to which you'd applied the mark over that relevant period.
Fair description of the type or kind, because there's, you know the arguments, my lord. ASOS, for example, my lord will remember these cases. Sometimes you can hold clothing at large, other times you can't. Sometimes you can. Sometimes it's only ladies' clothing, it's underwear, outerwear. You can go on salami slicing. And you may remember that in Merck itself, the question was pharmaceutical preparations at large or pharmaceutical preparations for particular indications. Now Merck is a good example actually of how these things work. No registry anywhere ever, no registry anywhere in Europe ever, including the United Kingdom, ever objected to an application for registration of pharmaceutical preparations, veterinary preparations in Class 5, ever. There comes a time when there's a non-use application, in which case they would tend to be cut down to therapeutic indications because that defines the nature of the goods for which there's been use. There tends to be a cut down at that point. But nobody has ever said that the filing of an application for pharmaceutical preparations is bad faith because it's overbroad. It's always solvitur ambulando and see what happens at the end of the revocation period. That's what it's for. My Lord, can I?
It looks somewhat incoherent that you would apply that approach at the end of 5 years, but not bother about this at all at the start when you file. It just looks as if you apply just a very broad approach at the start,
yes,
even knowing that this is never going to conceivably fall within the trademark use that's contemplated.
Yes.
And yet, after 5 years, we're cutting it all back. It just looks...
Well, it doesn't. They don't cut it back unless someone applies.
Well,
the register it's an inter partes thing. It's not an ex officio cut down. There are marks on the register that are never troubled by this.
Well, you could say the same at the start. If nobody bothers about challenging on bad faith, well, okay, it carries on.
Well, that's the system.
I mean, it's the sort of, not precise symmetry, but coherence by symmetry that the other side was putting against you. Anyway.
Yes, but the search for symmetry is misplaced. It's misplaced. It's deliberately lopsided, if I adopt the symmetry metaphor. It's deliberately lopsided. It's designed to function the way it does. That's why we got those questions going into the Court of Justice. Please address yourselves at the oral hearing to these three matters. Would the other side's argument render the revocation proceedings devoid of effet utile, useful effect? We got those questions for this very reason. My Lord, I'm extremely concerned about time. Mr. Roberts is to follow me on infringement, and I've only got until, however long, 3 o'clock. Do you mind if I press on?
No, we'll restrain ourselves. We'll press on.
Or give me some more time. No, you can't give me some more time today. Can you give me some more time?
No.
These are big issues. No? Right.
We have very full written submissions.
Yes, and I'm not resigning from any of mine, except the one I've got to correct when I get to it. Right, now, could I then just please look at 184 and 185? I've referred you to these in discourse. So, Mr. Justice Neuberger decided at A, 83A, Mr. Justice Neuberger decided in Knoll, and that's in 2003, page 184, my Lord. A trademark applicant, there was nothing in the legislation to support the contention that the trademark applicant was required to have an intention to use the trademark across the whole range of goods or services concerned, and that it was impossible, realistically, to argue that it would be inaccurate, let alone bad faith, for an applicant intending to use a mark for obesity products to apply for registration of pharmaceutical substances and preparations, or equally, dietetic substances adapted for medicinal use. Mr. Justice Sales, in Total, there is no requirement under the directive in the Act that a person applying to register a trademark, including in that case for database programs and databases and providing access to computer databases, etc., should have a positive intention at the time of application to use that mark across the whole range of activities covered by the specification of goods and services which it applies for. Mr. Justice Newgee in Jaguar Land Rover, applying without an intention to use the trademark for the entire range of goods covered by the application for registration, in that case motor land vehicles in Class 12, doesn't constitute bad faith filing, even though they'd been used only in relation to what you'd know immediately you saw it as a Land Rover, a four-wheel drive Land Rover. And in the present case, Lord Justice Sir Christopher Floyd in the Court of Appeal, can I refer you in the electronic numbering to, I'll start at page 250. That's his paragraph 42. It's convenient at this point to deal with an issue of interpretation of section 32.3. Suppose an applicant applies for registration of a trademark in relation to detergents. Its business in goods of that kind is, however, limited to household detergents, and it has no intention of branching out into industrial detergents. The applicant makes a declaration that it's using the mark, or if it has not yet commenced using the mark, that it intends in good faith to use the mark in relation to goods for which it has applied to register it, i.e. detergents in general. In my judgment, it is not possible to say in those circumstances that the applicant's declaration is false or even partially false. The applicant is not saying, and it's not required to say, that it has used or intends to use the mark for all possible types of goods which fall within the category for which it has applied to register it. The applicant is only required to say that it has used or that it intends to use the mark for goods of that kind or description. Any other interpretation would, as it seems to me, create an increasingly impossible burden on applicants, depending on how finely one sliced up the category of goods or services for which the application is made. And he points out later on, this was conceded in the court below. This point was conceded in the court below.
Well, yes, you may have to come to that particular point, the concession.
Well, I've listed them. I haven't got time. It's one of those I'm just going to have to say, could you look at my written submissions? I've got bigger fish to fry and very little time within which to fry them. Right. So I was going to show you that what the Court of Justice had said in Cactus in relation to applications for registration filed as ours were prior to the delivery of the IP translator judgment. So it's page 2531. What the case was about was, the appeal was about how can the EU IPO issue the statement that I showed you in 2012 and say that it doesn't go backwards in relation to ones that they've already processed. That's what the argument was pivotally about. Just pressing on quickly if I can, take you to 2540, the findings of the court. EU IPO was the appellant. In essence, the General Court criticises the General Court for having misread the judgments in IP Translator and Practica Bow, in holding that the authority derived from those judgments did not have a retroactive effect, and for having concluded wrongly that the designation of the class heading of Class 35 covers all the services within that class, including retail services in respect of any goods. EU IPO takes the view that that line of authority applies retroactively and that it should have been applied to the earlier marks, regardless of the fact that those marks were registered before the delivery of those judgments. In the judgment under appeal, the General Court considered that in the light of the principle of legal certainty, it was not appropriate to apply the authority derived from the judgments in IP Translator and Practica Bow to the earlier marks, given that they'd been registered before those judgments were delivered. The General Court therefore concluded that for the earlier marks, the designation of the class heading covered all the services within that class, including the services consisting in the retail of any goods. 37. As regards in the first place the scope of the judgment in IP Translator, it should be recalled that in 61 of that judgment the Court held that in order to comply with the requirements of clarity and precision, an applicant for a trademark who uses all of the general indications must identify the goods or services for which protection of the trademark is sought, must specify, you've seen that. the court 38, the court indicated in brand concern that the IP translator judgment provided clarifications only on the requirements relating to new EU trademark registration applications. It was prospective, not retroactive, and thus does not concern trademarks that were already registered at the date of the latter judgment's delivery. And 39, Communication 2 of 2012, can't call into question that case law. And the nub of it is in 43. It follows that from the foregoing that the General Court was right to hold that the authority derived from the IP translator did not apply to the earlier trademarks. So they're upholding on the basis of legal certainty, and in fact at the top of 2542 in 46 they identify protection of legitimate expectations as well. That's in 46. They're upholding on the basis of legal certainty and protection of legitimate expectations people who've gone through the process that my clients did in accordance with that practice 4 of 03. So that, in our submission, is highly material to the question whether you're going to look back from this end of the telescope and say that people who did that were acting in bad faith. It's highly material. The court was prepared to say that applications filed before IP translators should be upheld when they were filed in accordance with the practice prevailing at the time. And I say that that's what justice and fairness requires. So whatever your lordships might say about what the future is going forward, in circumstances where nobody has asked you to depart from any retained EU case law, I would say, and I'll make it a long stop if you like, I will say that it would not be just and fair to condemn these applications backwards through time in the light of what you've seen. Now, the argument on the other side, and by the way, there was evidence that we did act in accordance with the practices at that time. I'll just give you the reference. It's in paragraph 84 of the Court of Appeal judgment. Sir Christopher Floyd repeats the evidence which the judge accepted without criticism, and it's on the electronic bundle, page 263, 264. It's the evidence of Mr. Robert Tansey saying that we acted in accordance with the prevailing norms and standards, and if we had thought that it wasn't permissible, we would never have done it. Now, on the question of what is normal and what isn't normal, we've given your lordships chapter and verse, really. Your lordships might think too much chapter and verse, but we've done it. Could I ask you to look at electronic bundle 201, across to 204. So at 201, I've identified those practice statements which I've taken you to. In 202, I've identified the case law, including Cactus in 178. I've quoted from Netto Marken, where they're in Netto Marken, they're positively intending that you should use the alphabetical list. That alphabetical list contains expressions like computer software. They're telling you to use it. That's the ruling of the court. The Madrid regulations is very important. The Madrid regulations and the Madrid protocol govern what's called the registration of international trademarks. There's a centralized procedure. You make a filing through the World Intellectual Property Organization in Geneva, and then that is, you designate places and territories in which you wish to have protection, and the procedure for seeing whether you can have protection in the places you've designated is governed by the rules and the regulations. You see in 180 that the Madrid rules, Rule 9.4, and we've highlighted it in bold, the goods and services shall be indicated in precise terms, preferably using the words appearing in the alphabetical list. You're mandated to do that. We've identified what the alphabetical list contains. We've shown you in running down page 203 the harmonized database of pre-approved terms, all running at all relevant times down to this day, I can say without fear of contradiction, if I filed today, walked out that door and gave it to the registry actually on my way out the door, an application for the 8 selected goods and services, it would not be rejected at the filing stage. Now, in that connection then, could I ask you to just take on board, please, what I've put in my document. Pick it up at 183 in the electronic numbering. Making the point, I've referred you to SkyKick already. The other 2 cases which always get cited together are Pelican Travel and Bundesverband Souvenir. Then at 75, I refer to the Madrid Protocol, which specifies that an application coming through the international system may not be refused even partially by reason only that the applicable legislation will permit registration only in a limited number of classes or for a limited number of goods or services. IP Translator itself stands for the proposition it simply wouldn't have been possible for the court to rule as it did in answer to the 3rd question if broad coverage was prohibited or prevented. The court is telling people what to do. It's actually positively encouraging people to do the general listing in their application, to use the general terms, including from the alphabetical list. It's a decided authority which has the status under retained EU law of binding authority, I think, in this court. Chair Entertainment. That remains authoritatively, that's 77, authoritatively binding for the proposition that the Class 9 listing of computer software recorded is sufficiently clear to satisfy the IP translator test. The argument advanced by the applicant that 108 goods fell within that category is in that regard irrelevant. Everywhere you're told in the legislation, and so you see in paragraph 79, the use of general indications. 79 is the current legislation which follows from IP Translator. The use of general terms, including the general indications of class headings, shall be interpreted as including all the goods or services, and they're telling you to file using general terms which meet that standard. And the examples go on. Now, the case as I understand it against me is that for every trademark, for every individual trademark applicant, there is at the time of filing a platonically correct specification from which the applicant departs by way of enlargement at their peril. Because this is the inwardness of the argument about overbroad filing. Now, overbroad by reference to what? You can look at the transcript and you won't get the answer, and I venture to submit that there is no answer. What are the criteria? What are the criteria that the individual applicant who is required not to use an off-the-peg specification or standard specification, what is he required to do? He's going to be measured according to the argument on the other side against a platonically correct specification, but what are the criteria? And because it's an individual applicant test, the criteria are going to vary from one individual applicant to the next. You're a big trader, you're a small trader, you're a new trader, you're a non-trader. Use, by the way, under this legislation includes use by way of licensing. So use by a licensee is deemed to be use by a licensor. You can satisfy the test for licensing, for use by saying, I propose to take this mark and to set up a franchise or licensing system in due course, and I will license anyone who wants a license to use it on terms of my choosing. That's use. Now, the pain, and I use that word advisedly, the pain of being overbroad on a bespoke listing, if that's what you're required to do, is to have, according to the ultimate endpoint in my learned friend's argument, is to have your listings eliminated in their entirety for bad faith. Every listing that is overbroad relative to the criteria which they haven't specified, according to them, it'll be bad faith filing. Now, I do wish to impress upon your lordships that what the argument you're listening to is actually nothing less than an onslaught on the system that we have. No wording is immune from the death of 1,000 cuts approach. No wording at all. The familiar expressions, I mean, every trademark lawyer, anyone who looks at the law reports knows this. You will find again and again telecommunications services, pharmaceutical preparations, printed matter, clothing, footwear, confectionery, financial services, toys, alcoholic beverages. You will find those words used in countless specifications. And if you apply the death of 1,000 cuts approach, which is, but how broadly did you intend to use, exactly as Sir Christopher Floyd said, it will be an infernal burden on you, and you'll never be able to discharge it to the ultimate width. Now, just to bring that point home, we did some searches. So 2 days ago, it seemed like maybe 2 days ago, the trademark, the United Kingdom Intellectual Property Office UK IPO, is a registered trademark. The UK IPO has registered itself as the proprietor of that trademark in Class 16 and Class 42 as of December 2006. Somebody filled in the application using the form, the Section 32(3) provision. Class 16, printed matter at large, publications at large, paper and paper articles at large, cardboard and cardboard articles at large, and printed data. Now, on the other side's argument, they could serve an application for revocation on the registrar on the way out the door saying you're overbroad. You filed, your intention was not as broad as your filing language. I won't even stop on what HMRC has got. I mean, it's endless. But I will, just to take this further, we worked our way around Westminster Square. The House of Commons has countless registrations. The House of Lords does. Interestingly, the Supreme Court has not got a registration for its emblem, I noticed, when we searched, even though you have sales of very nice goods through the basement. Westminster Abbey is a registered trademark and has been since 2002. The Dean and the Chapter of the Collegiate Church of St. Peter, Westminster, has registration in umpteen classes, including classes 9, 16 and 25. They've got computer software without qualification in class 9, printed matter, paper, cardboard, clothing, footwear, headgear. What will happen if your lordships adopt the test on the other side is that no one will ever sue on a trademark again in this country, because the language will always be capable of being tripped up on the test that they've propounded for you. Now think about it in terms of commercial realities. Marks, registered trademarks, are property. They are assignable and transmissible in all the ways that property can be assigned. It is common for people to get marks out of a liquidation. It's common for people to buy businesses and so on. And it's common for people who want to use a mark and find that there's an anterior registration to buy it. And they can buy it and they can use it in good faith and buy it and use it. Are they seriously to be tripped up on the basis that somebody from in their chain of title going back to the filing date used language which was broader than that person at that filing date, had a subjective intention to use, because that's the test, a subjective intention to use, in circumstances where you can't actually define what the requisite intention is? And then you have the EU-UK withdrawal agreement. I've checked the figure with the registry officials behind. On exit, so there was a long weekend running into the bank holiday on January the 1st of 2021, 1.6 million registrations were added to the UK register because they cloned out the whole of the then existing EU database. All of those will have been registered according to the EU system that I've been discussing with you. None of them will have been subjected to this intention to use requirement that's being argued for. And the requirement under the withdrawal agreement is that they be provided with enforceable rights without examination and without charge in the United Kingdom. And what will we do? We will end up exposing all of them to bad faith objections because the UK equivalents are deemed to have been registered under the the 1994 Act with the same filing date, they'll all be open to bad faith filing objections exactly of the kind that have been articulated here. It will never end. This cannot be. This is actually the kind of thing the whole system was designed to avoid in the first place. Now I've got to speed up. The grace period. If I can be, I'll do this off my written document. So we've pointed out on pages 178 and following on the electronic bundle, we pointed out on 178 and following that as a matter of legislative history, it was a deliberate intention that there should be no requirement for use or intention to use, and we've given, contrary to the travaux preparatoires that the other side have identified for the directive, the relevant travaux preparatoires are those relating to the negotiations under the TRIPS agreement in the World Trade Organization. Those led to the provisions which govern at the international plane the implementation within the EU, and they show quite clearly that the intention was on the part of the EU legislator to adopt the regime that has been adopted. And just in passing to note, in my paragraph 62 on 179, the importance of the TRIPS agreement cannot be understated. There's an abundance of case law, so compliant and compatible interpretation is one of the strictest rules in relation to intellectual property legislation within the EU. You must comply with the TRIPS standards, and that passage from the Court of Appeal in Anand Kasai makes the point. So now, forgive me. Can I turn you in to 191 in the bundle, running through to 193. The grace period of 5 years, the case law is solid. It doesn't begin until the registration period, until registration is complete. It provides a grace period of 5 years during which you cannot be required to provide proof of use, and no application for revocation of the registered trademark can be made. You can't even file it during that 5-year grace period. That is the intention of the legislation systematically. There is nothing, we say, paragraph 125, there's nothing in the CJEU judgment that in our respectful submission would enable your lordships to say that the court was devising an accelerated or an abridged cancellation procedure for non-use, or in any other way trying to dispense with the 5-year period. There's no way in which the judgment of the court can be said to have done that. And what's more, it's a fairly easily deducible proposition that they were at pains with their additional requirements for bad faith filing not to do that. They wanted to ensure that the test they established for bad faith filing did not override, undercut, or in any other way deprive the grace period of its intended effect. The judgment in Hasbro stands for the proposition that in an appropriate case the court can turn around and say, well, you've had your 5-year period, you can't have another one, you've had it. Thank you, goodbye, you're trying to circumvent the legislation. The safeguards are extremely important. So, on page 192, at 131, it has always, that is, at all stages under the EU trademark legislation, been possible for defendants to claim revocation for non-use defensively in actions for infringement and threatened infringement, otherwise than by a counterclaim. You don't have to wait. You've always been able to defend yourself against against attack by someone using an unused mark by showing that it could be revoked, or the extent to which it could be revoked for lack of use. 132, since 2019, non-use has been available as a defence in actions for infringement in the UK, on UK national registered marks, and those are additional to the procedures, the freestanding procedures available for revocation. The trial judge, Mr. Justice Arnold, in our case pointed out in paragraph 7 of the main judgment, it can't be contradicted, that there was nothing preventing SkyKick from claiming revocation for non-use in relation to the Sky registrations in issue. Not only have they not done so at any time, they haven't done so in relation to the UK ones which came into existence on Brexit. If they'd done so, we could have had a real-world assessment of what use there had or hadn't been, instead of an abstract snapshot assessment at the filing date of what the intention was or wasn't, if the intention was, and insofar as it was, relevant. On our side of the case, it's a mystery. They don't want to know, and they don't want the court to know, what the outcome of a properly presented and duly adjudicated claim for revocation for non-use would have been.
What is the date from which the non-use in those circumstances applies in terms of revocation?
Yes. May I supply that? The information's here. I can't. Yes.
Certainly. Well, at some point, could you please give us the answer to that? Because the bad faith goes back to the date of application.
Bad faith is purely at the date of application.
Yes.
Snapshot.
But revocation for non-use applies as from what date? If you let us have that at some point.
I can give you the dates, but I can answer the question. The question is, as soon as you've got a period of 5 years continuous non-use, and that period itself can only begin on the 5th anniversary of the date of the registration of the trademark concerned, because that's the earliest date preceding which you can have 5 years continuous non-use. Now those dates have we got them?
Sophie Schedule 1.
Sophie, you may have heard that. Sophie Schedule 1, so which one is this? Is this? Oh, that's right. So using...
Let's have it later, Mr. So I don't want to take you out of
those details are in electronic pages 94 to 96. Thank you.
Thank you.
Now, but they haven't applied. So there's only one reason that I can think of why they haven't done that, and that's because they know or suspect that if they did, we would still end up on my side with specifications of goods and services from which they would not be free of infringement. That is the only reason that I can supply for them not doing this. It's a great mystery, and the judge has rejected the suggestion in paragraph 7 of his judgment that they couldn't have done it. Right. Dishonesty. On electronic 2488, is the opinion of Advocate General Sharpston in the Lint case, and unswervingly, 2488, it's paragraph 60, in particular, little 2. The General Court has never deviated from her formulation of the test of bad faith. I have never seen a judgment in which, even when they refer to Cotton and in which they refer to Sky, down to this day, they have never deviated from her formulation of a dishonest intention or other sinister motive. It is an ever-present feature of the General Court case law. They stick to it like glue. Now, the argument that has been addressed about how it all collapses back into abuse of process, and that, I have to do this quickly, the judgment of Lord Justice Arnold in Lidl and Tesco was a reframing or a reorientation of the judgment in our case in Sky, delivered by Sir Christopher Floyd. There's a reframing of it. I'm going to try and get to it, but the suggestion is that you don't need dishonesty, that dishonesty isn't the only circumstance in which you can find bad faith filing. It's there to prevent abuse of process. Now, that is an argument that my learned friends, Mr. Malinich and Mr. Barron, have run twice and lost on in the General Court. So to quickly show you, if you can go to electronic page, started at 2256. Sorry, I think it's right. Excuse me, my lord, I've just picked up possibly the wrong one. 1 second. Forgive me, my lord. 25. Yes, 2556 was the beginning of the citation I was looking for. Mr. Malinich and Mr. Barron appeared for the Foundation for the Protection of the Traditional Cheese of Cyprus. They had a bad faith objection. They took it on appeal to the court. The argument that they addressed to the court on the second plea you can see from 2559. Paragraphs 97 to 99. The second plea consists of two parts. First, according to the applicant, the Board of Appeal applied an incorrect test to assess the bad faith of the proprietor of the contested mark, since it found in essence that as the earlier mark consisted of a word which designated a specific type of cheese, a cheese producer could not be criticised for using that term. Secondly, in support of its conclusion that there was no bad faith on the part of the proprietor, the Board of Appeal found that there was no indication of dishonest intention on the part of the proprietor. This is a submission, whereas in the court's case law, dishonesty is not a criterion for assessing bad faith. The Board of Appeal therefore erred and should have concluded that the contested mark was filed in bad faith and was therefore invalid on that issue. And the court responded to that on page 2562. 2561 in paragraph 117. Moreover, concerning the reference by the Board of Appeal to the criterion of dishonesty, contrary to what the applicant claims, that criterion appears several times in the court's case law, as is submitted by the EU IPO. EU IPO gives the citations. That criterion is also referred to in essence in point 60 of the opinion of Advocate General Sharpston in Lint, in the sense that the dishonest intention of the person making an application for registration makes it possible to assess that person's subjective motivation. The Board of Appeal was therefore entitled, without committing any error, to rely on that criterion in particular in order to assess the bad faith of the proprietor of the contested mark. And I'll just give you the page references. The second time that that argument was run by my learned friends and in which the court rejected it, you'll find on pages, I'll just call the numbers, 2771 is the beginning, and the corresponding paragraphs are on pages 2775 and 2777. You'll also remember seeing the draft common practice, which says that it's a mandatory factor. At one point yesterday, there was discussion of defensive registrations. Excuse me.
This is the penumbra of the penumbra, I think, Mr.
No. There was a question, the submission comes from what Lord Justice Arnold referred to in Little versus Tesco about defensive registrations. And there came a point where I recollect my Lord Burrows asked my learned friend, Mr. Speck, is an application for registration, de facto for a defensive registration, is it a bad faith filing? And my learned friend said yes, if I heard him correctly, which I think I did. That is a serious oversimplification. Now, in order to make the point I want to make, I need to take you to Lidl and Tesco to give you the context. It'll start for present purposes at 2227. Now, so I'm into the section. Yeah, 2227. This is where Lord Justice Arnold is coming back in Lidl to discuss the concept of bad faith. So if I take you into his text of his judgment, 2234, he's got the heading Case Law on Bad Faith. And there's a list in paragraph 15 of a number of cases, but the one you would need to notice is Target Ventures. In italics, I suppose it's about 10 lines or so into paragraph 15. Target Ventures is the new case, and Lord Justice Arnold is going to go on and say this is a new and important authority. And he mosaics it with Kindersnappy to establish a proposition which we say involves very significant over-interpretation of those two cases. So he identifies Target Ventures in paragraph 15, then he refers to Sky and SkyKick in paragraph 16, and he says, the cases I've listed in paragraph 15 above, with the exception of Target Ventures, which was not referred to in Sir Christopher's judgment and may not have been cited, as follows for relevant purposes. Now, he's right. We didn't cite Target Ventures, and the reason we didn't cite it is because it's not relevant and it doesn't actually substantiate the proposition that the Lord Justice goes on to place upon it in due course. Now, going on through pages 2236 and into 2237, you have paragraph 19. Paragraph 19 is part of what has been causing some difficulty and is part of what led to the application to intervene by Lidl in this appeal. Although the Court of Justice does not say so in terms in paragraph 19, it's clear from the Court's reasoning that bad faith is not limited to dishonesty. This is consistent with the analysis of the Advocate General in Lint and with the judgment of the General Court in Copernicus and Hasbro. Now, the judge is here, the learned Lord Justice is here unshackling the bad faith objection, or potentially unshackling the bad faith objection from dishonesty. That isn't what the Advocate General said, as I've just showed you. The Advocate General said dishonesty or other sinister purpose or sinister intent. The judge says in paragraph 22, a vexed question in this field is whether it's sufficient to establish bad faith to prove that the applicant for registration didn't intend to use the trademark. The CJEU answered this question in Sky CJEU as follows. It would have been appropriate at some point to say that the judgment of the Court of Appeal in our case, that Sir Christopher Floyd had stated in terms that absence of an intention to use is not in itself sufficient. That's paragraphs 70 to 72 of our judgment. And the judge, if I take you on, refers to the appeal starting on 2243, and you're going to see in this portion of the Lord Justice's judgment what seems to be the source from which quite a few of the submissions you received yesterday from the appellants have been drawn. Paragraph 36. The starting point is to be clear as to the nature of Tesco's bad faith case. To be fair to the judge, I suspect this was not as clearly articulated by Tesco to the judge as it was to this court. Indeed, as I shall explain, one of the key authorities was not cited below, and that you will see its Target Holdings is the key authority not cited below. Tesco's case in a nutshell is that the wordless mark is a defensive trademark, that is to say, a trademark registered by the proprietor not with any intention to use it in the course of trade, but in order to secure a wider legal monopoly than the proprietor is entitled to by virtue of the trademarks that the proprietor does use in the course of trade to indicate the origin of its goods and/or services. And then there's a reference to evergreening. And then in paragraph 38, the judge is dealing with the first aspect, which is the defensive registration point. It should be noted that prior to European harmonisation, some national systems expressly permitted defensive registrations. I shall refer to these as national defensive trademarks. He cites Il Ponte Finanziaria, and he cites Rintish and Ida, and he concludes that paragraph by saying that national defensive trademarks are incompatible with the scheme of the European legislation and few remain upon the national registers. Now, there are always three cases which are cited in this connection. The third one is Rivella, and I will, if I may, I have hard copies, it's a short one. May I hand it to your lordships just to make this short point that I need to make on Rivella? Yes. Would that be acceptable, yes, your lordship?
You have a copy for Mr. Speck?
Yes, I did notify them in advance. Thank you.
Thank you.
Now, Rivella was a case where they tried to say that because there was an agreement, an international agreement between Germany and Switzerland, which effectively shielded trademarks on the register from a non-use attack in circumstances where the requirement for use could be met by showing there'd been use in Switzerland.
If I interrupt you just a moment.
I'm so sorry.
It's helpful to have the hard copy, but we do in fact have it electronically.
I'm never quite sure whether it always filters through to you. Thank you for that.
It's a separate document, a separate electronic document.
Yes, thank you. Right, so paragraph 7, I think, in the judgment, leaving aside the headnote, paragraph 7 in the judgment brings the point up. The 1892 Convention, Article 5.1 of the Convention between Switzerland and Germany on reciprocal protection states that the legal disadvantages which under the laws of the contracting parties occur when a trademark has not been used are precluded if the use takes place in the territory of the other. So you can't take a mark off for non-use within this regime if there's been use in the other of the signatory parties to the International Convention. And of course, Switzerland isn't an EU member state. Now, the ruling on this is clear and to the point. I think I'll pick it up. Paragraph 46 leads you into the findings of the court. The findings of the court begin at 48. As a preliminary point, it should be borne in mind that the community trademark system is an autonomous system with its own set of objectives and rules. Rivella cannot call into question the conclusions drawn by the General Court from the judgment of the Court of Justice in Il Ponte Finanziaria regarding the concept of use. The General Court recalled that the national concept of a defensive trademark, pursuant to which an earlier trademark is protected on the basis of national law, even if its use cannot be established, cannot be used to oppose the registration of a community trademark. The position would be different only if the legislation governing the community trademark didn't harmonise the concept of use of a trademark. However, the directive, Article 10, which is intended to harmonise the national laws on trademarks, provides, and so on, that it's got to be subject to the sanctions providing for by that directive, and therefore you get the point which is stated in paragraph 52. The General Court did not err in ruling that the concept of use of a community trademark in the European Union is exhaustively and exclusively governed by EU law. And what that means is there is no law prohibiting the registration of defensive marks. The law, which is exclusively and exhaustively stated in the legislation that we are concerned with here, leaves no room for them. And to invoke the concept of a defensive mark is to do no more than to say that you reaffirm by doing that, you reaffirm and reassert the non-use provisions, because they are the provisions which govern the requirement for use within the European Union. And all you're saying when you say that a defensive trademark isn't protected is it can't pass the test for revocation under those exclusive rules. So the point I'm making is that it's not right to set up, as the exchanges occurred yesterday, that a defensive registration is ipso facto a bad faith filing. The rule is actually that you cannot, under the rules which apply in the European Union, end up with a situation in which marks are protected defensively. It's a statement about the non-use provisions. It's not a statement about the filing of applications for registration. It's an assertion of the rule on non-use. So the judge, I'm going back to 2244. The judge is still on the aspect of defensive trademarks. Tesco rely in support of this aspect of their case on two authorities. The first is my lord sitting as the appointed person in Ferrero, that's Kinder Snappy. And the judge is going to mosaic this with Target Ventures, as you're about to see, for a proposition he's going to come to. The hearing officer found that the proprietors, 42, found that the proprietors had made the applications in issue in bad faith because they hadn't intended to use the marks. Mr. Kitchen held that the hearing officer was entitled to found this allegation established on the evidence before him. He quotes what my lord had said. Mr. Kitchen went on to reject the proprietor's argument that the hearing officer had erred as a matter of law in concluding that an absence of bona fide intention to use a trademark at the date of filing could constitute bad faith at all. Insofar as Mr. Kitchen held that lack of intention to use without more meant the applications were made in bad faith, his decision is at least open to question in the light of Sky CJEU. As can be seen, however, it was the applicant's pleaded case and evidence that the proprietors had not merely not intended to use the trademark, but had intended to obtain a broad scope of protection for the word Kinder when they'd not registered Kinder on its own, presumably recognising that it would not be registrable. This is so slender. This is a decision which I venture to submit that it wouldn't be written in the form in which it was then, today. The judge is doing a reorientation on Sir Christopher Floyd's judgment here, and he's doing it by reference to Kinder Snappy, and he's acknowledging that Kinder Snappy was in substantial part decided on a basis that is at least, he says, open to question in the light of the judgment of the CJEU. This is a very poor basis on which to reorientate the judgment of the Court of Appeal in our case. He goes on then to deal with Target Ventures in paragraphs 44, and I want to look at Target Ventures. If I take you to 46, where he's quoted from it, I will go, if I can, to Target Ventures. He says in 46, this reasoning indicates that an intention of the kind alleged and evidenced by the applicant in Ferrero is capable in law of amounting to an objective, relevant and consistent indicium which, coupled with a lack of intention to use the trademark in question, amounts to bad faith. The judge is stretching the concept of bad faith, having said that dishonesty is not a requirement. He's stretching it on the basis of these two cases. The first one, with respect, won't bear the weight on its own, or when you add it to the other one. May I ask you then to look and see paragraph 50 is where the judge was going. This takes me to the second reason. The question raised by Tesco's claim is whether Lidl's filing strategy amounted to an abuse of the trademark system. In the light of the case law discussed above, and in particular Target Ventures, it's clear that for an applicant to seek unjustifiably broad protection may amount to an abuse of the trademark system, which constitutes bad faith. Whether it does constitute bad faith is at least to some extent a fact-sensitive question. Now, that is where my opponents were drawing arguments. This is where they were drawing arguments from in the course of their submissions yesterday. While we have it, before I go to Target Ventures, could I ask you to look at 55, which, at least to my eyes, was a rather startling thing. So the Court of Appeal, Sir Christopher Floyd, in his judgment, found that the judge had adopted, in our case, an unfair procedure for dealing with the bad faith objection. And the judge says here that he confesses that he's unable to see, basically, why that should be so. Basically saying, I don't see why they reversed me. And if I'm not mistaken, when he says at the top of 2250, it's not necessary for the applicant to plead, I believe, on reading that and taking it at face value, he's actually purporting to reverse the Court of Appeal in our case on that point. Now, I asked you when I was looking at the lecture he'd given soon after delivering our judgment, when he said the jury's out on the Court of Justice and broad specifications. The judge, Lord Justice Arnold, has never, ever made a secret of his antipathy towards broad specifications. And well, he hasn't made a secret of it. It's there for everyone to see. And this is this judgment that has been given in Lidl and Tesco is in that vein of dissatisfaction with the existing state of the law in the Court of Justice. Now, as I've said to you, Lidl and Tesco has been causing problems. And when I show you, I'm over time for 1 o'clock, but when I show you Target Ventures, your lordships will, I hope, see why this has been erected, this reasoning has been erected without any proper foundation.
Well, is that a convenient moment?
I wouldn't say no.
We'll adjourn then and resume at 2 o'clock.
Thank you, Madam.